Okay, so let's talk about marijuana testing. How many of you do new hire testing? Okay, and I assume that new hire testing includes testing for marijuana, right? Okay. Right. Issues back there. So what's interesting, and I imagine a lot of you have felt this. You know, we've had lots of clients who had been testing for a long time, testing new hires, and then after it became legal, even medically, but particularly when it became legal to use recreationally, so many employers were finding they just couldn't hire people. They couldn't find people because everyone was failing tests, right? Drug tests. This sort of goes along those lines to, I guess, try to eliminate that situation by making it unlawful to test new hires for marijuana. But the thing to keep in mind is there are a ton of exceptions, and those exceptions are very broad. So broad, so for example, right, firefighters, none of you are public sector, so not an issue. EMTs, are there any private ambulance companies or anything in here? Okay. Positions that require employees to operate a motor vehicle. Well, that could be interpreted pretty broadly. Does that mean on a daily basis? Does that mean on a weekly basis? Does that mean just at any time if an employee might have to operate a motor vehicle as part of their job, then the exception applies and you can still test. My inclination, because I'm on the employer side and a little more aggressive, is to use these exceptions as broadly and interpret these exceptions as broadly as you possibly can. But that's going to depend on your risk tolerance, right? So obviously we don't want to get into litigation, but if you have someone who needs to operate a motor vehicle and that's identified in their job duties, I would say that's fair game to say that an exception applies, right? But it's got to be reasonable. If you just throw that into every job description you have, probably not going to work, right? So positions that federal or state law require employees to submit to screening. So there are some where, for example, in healthcare where you have to submit to screening anyway by virtue of another law. And so if that's the case, then that other law that requires the screening trumps this prohibition, right? Positions that in the determination of the employer could adversely affect the safety of others. Well, that's everything, right? So this is the one, the hole that's so big you can drive a truck through it. And this is the one that if you need to justify new hire testing, you probably can. Again, though, it's going to have to be reasonable, right? So, if you have, let's say, for example, you have a receptionist sitting at the front desk answering phones. That's all that person does, right? If that person, it's unlikely that you can justify that that position would adversely affect the safety of others, right? If they used marijuana, right? Now that doesn't mean if they're under the influence and they're impaired while they're out, you certainly can't. But this just has to do with new hire testing, right? So, for that type of position, for like the receptionist, where safety is not a concern for that position, the safety of other employees, it's going to be hard to justify testing that position, right? But if as part of that person's job duties, maybe that person is like the safety officer in your company, and if there's a fire, they're the ones who have to round everyone up and head out the door. That would be a way to fit that position into the exception, right? All right, so the other part of it is the law also requires an employer to accept and give appropriate consideration to an employee to additional screening, right? That the employee can use to rebut 30 days within the first 30 days of employment, right? So what this means is, let's say one of these exceptions apply and you do testing okay, and you find out that the person has marijuana in their system when they do the testing, and based on that, you decide to revoke their conditional offer of employment, okay? What this says is within the first 30 days, they can get retested, and if they retest and pass, the employer has to give appropriate consideration, whatever that's supposed to mean, undefined, like so many of these statutes, has to give appropriate consideration to that second test, right? Honestly, it doesn't mean a whole lot, right? So, you know, if you want to give the person the ability to test a second time and they come back and they say, hey, I passed, you know, the second test, well, that's great. You can decide, all right, maybe we'll hire them, maybe we won't. Because appropriate consideration is so broad, who knows what that really means, right? Remember, this requirement does not apply if it conflicts with the provisions of an employment agreement. So if you have a specific employment agreement with employees that says, hey, we're allowed to test you, the employee, by signing that agreement, has agreed to those provisions, then you can do the new hire testing. A collective bargaining agreement. Does anyone have union employees here? Anyone subject to a CBA? All right, good for you all. Or positions funded by a federal grant. I mean, that kind of already ties into if it's inconsistent with federal law anyway. But, you know, a lot of companies will have even small federal grants for various things. And so that's another exception that this law does not apply to. The other thing to keep in mind, this doesn't have to do with the new law, this has always been the case, is that when you hire, drug testing, drug and alcohol testing falls under the Americans with Disabilities Act. And that requires that you have to have made a conditional offer of employment before you can subject someone to testing. So that's something a lot of employers forget, and they'll send someone for testing before they've made that conditional offer. And technically that's not valid, you're not supposed to do that. I just want to throw that in there. It's not the new law, but it's something that employers miss pretty frequently. Any questions on this one? Yeah.
Yeah, I have a question. Excuse me. I hire pilots and I hire salespeople.
Okay.
Do I have to be consistent within my company to hold them to the same standards of the testing?
No. So
you can do it by position.
Yeah, exactly. So she's absolutely right. You can do it by position, and what this law makes clear is the exceptions. It's okay to apply the exceptions to certain people and not others, right? Depending on what type of job they're doing. The pilots, obviously, you're going to test, right? Because that's a safety issue. The salespeople, maybe not. It depends on whether you can creatively justify one of the other exceptions, right? But, you know, probably not. If they're truly just traditional salespeople, it's going to be hard to fit under one of these other ones.
Unless they give a quote that gives away the farm.
Yeah, that's true. That's true. The other thing, though, to keep in mind is, and you know, we could talk afterwards if you want, because I don't know the details of your business, but positions that are inconsistent with federal and state laws, if you're regulated by the FAA, for example, that might be a justification to still require testing for everybody. I just don't know. It'll depend on your specific situation.
Okay.
The other thing to keep in mind is this is only new hire, right? This does not change anything in terms of reasonable suspicion testing. So, you know, if someone gets into an accident, they've been working for you, they get into an accident and you test them, that's totally valid. You can still do that. Random testing while they're employed, that's fine. This is all just new hire. So all that other stuff is still fair game. All those, you know, testing otherwise is still fair game. Okay. Yeah.
On that note, how do they determine if it's legal for recreational purposes, right?
Mm-hmm.
And let's say I get hurt at work, have myself, and I get tested. How do they determine if I did it on Saturday, if I did it during work? I know the level of the THC could be higher, but it's legal, right?
Well, so is alcohol, but
So alcohol doesn't stay in your system as long as THC.
true. So that is the major flaw in all of this, and with regard to testing, is that, just like you pointed out, THC can stay in your system. If you're a habitual user, it can stay in your system even longer. Even if you haven't used it for a long period of time, it might still be in your system. So what you have to do, so there are two things that come up with the scenario you just said. One is, what do you do as the employer in terms of discipline? Do you discipline the person, right, for causing an accident? Okay, so the first thing you have to do is determine, were they impaired at the time of the accident? Like you said, you can send them for testing. They might have THC in your system, but they might say, well, I didn't smoke for 2 weeks, and it's still in their system. Then you have to use other evidence to determine whether they were impaired. So other people who were around them, you got to interview them and say, was this person acting, funny? Did they have bloodshot eyes? Were they, did they seem to be under the influence, right? So that's the disciplinary part of it. The workers' comp part of it, it has to do with, there are exceptions in workers' comp if the person is using lawfully, right? But if you find that, if in the workers' comp insurance company's investigation, if they find that the person was under the influence and it was just recreation, then they treat it like alcohol. If it was their fault and they were under the influence, they don't get covered. Now, compare that to if they had a medical card, right? So there is an exception under the workers' comp laws for medical cards, okay? So if they were using it consistent with what their medical card allows, which medical cards don't say, there's no prescription, right? So workers' comp might cover them if they have a card, right? Any other questions? No?
Sorry guys, just to sum that up. So pretty much anytime we send anybody for drug testing, make sure you have a witness with you. Make sure there's 2 sets of managers at all times. You guys know your employees. So if you know that employee is normally quiet, to himself, and now he's acting wild and he's out of his normal personality, that's when you're able to determine that they are under the influence at that time. But there's nothing that will prove that, hey, I did in fact smoke right before I clocked in and I am still high, and there's nothing that can prove that, hey, I smoked 2 weeks ago and it's still in my system. So you guys just need to make sure that we're documenting. We have a witness, interview the employees around, get statements, right? Bobby was acting this way. This is what he did. This is what he said, just so you guys have documentation of all of that.
For anybody that might be interested, I have a guide, steps to follow when you are you're suspicious about an employee being under the influence. It gives you step by step and what to look for, how to conduct the investigation, and how to document it. Anybody that might want.
And maybe I'll send a massive email again after our meeting, how we did last time, with a couple of documentations attached, just so you guys can keep for future reference. But it's just very important that we always have a witness. We can't just assume that, Bob smoked before work.
Right. Yeah, Debbie.
So we haven't had it happen, but I know it's coming. Someday, somebody in the healthcare field in one of our facilities is gonna have an accident, none of which is his fault, or maybe
Right.
not impaired, completely fine, smoked weed on the weekend or did whatever, recreational.
Right.
Doesn't seem impaired, but it comes back that, excuse me, he's positive.
Mhm.
So we have a 0 tolerance for it right now.
Right.
What do you do in that position? I mean, is that
Right.
call Tony?
Yeah.
I mean,
Right.
because we've always,
So-
I know it's coming, I just don't know how
Yeah.
we're gonna handle it.
So, we're slowly inching our way away from being able to have a 0 tolerance policy across the board, and laws like this are making it harder to do that. As long as it is still unlawful under federal law, I'm still comfortable advising that you can maintain a 0 tolerance policy for most situations. There may be some unique exceptions, but for most situations.
Or let's say they have a medical marijuana card.
Right.
Then you have to make an exception, correct?
Correct.
Generally, yes. You
Because
do.
if the workers' comp
Yeah.
would accept that type of thing.
Yeah, I mean, again, it's subject to litigation, and there's been no clear direction from the courts on how to interpret all that, right? But,
I'm sorry, with a medical marijuana card, you will treat it like you will treat any employee that's using a prescription,
Okay.
a regulated prescription.
Right.
Exactly the same.
It just encourages everybody to go get a card.
Yes.
correct,
And unless you change your policy to, it's under federal guidelines because it's still,
That's what we
illegal,
have, Yeah.
then, but again, you can't prove that that person has smoked right there and then.
So
It
it
goes,
could be a case by case.
Yes.
There's no.
Definitely
Yeah,
a
it
case
will
by
be.
case.
Okay.
And that is the challenge, that it's hard to pinpoint if the employee was actually there.
Okay.
So that's why you need to pay attention to the other circumstances surrounding the incident.
Just out of curiosity, like how likely is it that you get a workman's comp claim out of this? Because I have a random situation, just hypothetical. Just say you find a can that you know was used to smoke marijuana out of, like in the back warehouse, and you have like more than 20 employees back there.
Mhm.
I'm not gonna random drug test all 20 of them, and then, I mean, the likely chances that someone's gonna say, oh, so-and-so was smoking. I mean, it just seems like your hands are tied as an employer, really.
Well, it does become harder, so that's up to you. If you do want to test it, all those folks who were back there at the time when you found it, you reasonably could. I mean, that's more than enough for a reasonable suspicion, right? If no one's gonna say who did it, basically. You
Right, but if
could,
it stays in their
you could do that.
system, and no one, like, a witness doesn't say anybody was accurate, I mean, like,
There's no one, if you don't
There-
have other evidence of impairment,
Right.
right? It's gonna be hard to do anything about it.
right, okay,
Okay.
yeah, I just want,
Yeah.
okay, I just wanna make sure I'm
And
understanding.
that's the answer. And workers' comp only comes into play if there's an accident, right?
Right.
Workplace accident. So then you have to, kind of do a more thorough, deep investigation. And the workers' comp insurer will do one as well. Okay. Anybody else?